Morning to those who've joined us already. This is Kristen O'Neill with the Committee on Open Government. Um, Those of you that are in the eastern part of the state, probably covered in snow like I am. I'm working from home, so fingers crossed that power and internet stays. If for some reason we get disconnected during the program, that might explain why, but so far so good. Wait until 10 o'clock to get going. But thank you for joining us today. Morning, everyone. This is Kristen O'Neill with the Committee on Open Government. We're here today. We're here to provide an information session regarding freedom of information, New York State Freedom of Information Law, for the basics, statute, also over any updates that have occurred in the past couple of years regarding the statute. Tell me my audio is distorted. Okay. Tell you what. Moment. See. I sound like a robot. Fortunately, I'm working from home today because of the weather we're having. See, everyone could just give me a moment. I'm going to put that in a chat function for people that log on in a second. Let me see if I can find a set of headphones. Which might help the situation. So if you're patient with me, and I will see what I can do just a moment.
Hello, everyone. Can anyone tell me whether this makes any difference to the program? Do I still sound garbled? Oh, wonderful. Great. Thank you for letting me know. Okay, hopefully problem solved. Great. Thank you for your patience with me. Okay, so today, as I said, we're going to be talking about the New York State Freedom of Information Law. We'll go over the basics and provide some updates. To start out with, I'll let everybody know that this program is being recorded. And we have a page on the Committee on Open Government's website, which, let's see, I think I have a picture of, that's my contact information. Our office telephone number is 518-474-2518. And our website is www.opengovernment.ny.gov. Just want to give you a quick peek at what our website sort of looks like. This is our home page, and from the home page, you can access quite a bit of information. We have under the Freedom of Information Law drop-down box, there's a copy of the statute, regulations, advisory opinion, case law summaries. Same goes for the open meetings law. We have a news heading, but not that I can show you from this picture, but if you scroll down a little bit from our home page, you're going to see a series of boxes that say I would like to. And from there, you're going to see an option. It should be pretty visible, clear, that says view training materials and recordings. So if you click on that box, it's going to bring you to all the recordings of the programs that I've provided online over the past couple of years. The one that we're doing today should be up within a week or so. I just need to, once it's recorded, I send it to our IT folks and they get it uploaded for us. And two, I have a copy of my PowerPoint presentation, the one that you're looking at today. So if you're looking for the materials or a recording of the program, I will have it up on the recording. Materials are already there. A copy of the recording should be up within a week or so. So get that sort of bit of housekeeping business out of the way. In 1974, New York State passed its original of information law, but it was fairly limited in scope. It only provided access to 9 categories of records, and it wasn't a particularly popular version of the statute, so the legislature repealed it and replaced it with what is essentially the current version of the statute. Of course, there's been updates along along the road, but the basics is that the New York State Freedom of Information Law is based on a presumption of access. Now, what that means is that you start with the assumption that all government records are subject to FOIL disclosure. You review those records and the portions of the records to determine whether the record or any portion of it fits into one of the permissible grounds for denial. So we get questions quite frequently in our office as to whether a record is foilable, whether it's a public record. And I always encourage people to sort of flip that question on its head, assume that all records are foilable, so to speak, that all records are public records, unless the agency can assert one of the statutory grounds for denial that we're going to discuss. Who is covered by FOIL? The statute uses the term agency. Agencies are subject to FOIL. An agency is defined as any state or municipal department, board, bureau, excuse me, division, mission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental proprietary function for the state or any one or more municipalities thereof, except judiciary or the state legislature. So of course that's a lot of, sort of mumbo jumbo legalese, but in short, it becomes quite simple, because if you think about it, sort of starting at the top, for the governor's office, and all of the agencies under the control of the governor's office are subject to FOIL. The Office of the State Comptroller, the Office of the Attorney General, those are all government agencies subject to FOIL. As you work your way down, county government level, city governments, towns, villages, fire districts, water districts, school districts, libraries, public libraries, I should say. There is a distinction between not-for-profit libraries and public libraries, but public libraries are subject to the Freedom of Information Law. So it's any entity essentially performing a governmental function, except the judiciary or the state legislature. So the courts are exempt from the Freedom of Information Law entirely, and that doesn't necessarily mean that you can't access court records, that the court records aren't to a large extent public. It's just that the Freedom of Information Law isn't the statute that governs access to those records. And with the state legislature, the Freedom of Information Law does govern access to state legislative records, but it's sort of a carve out in terms that instead of them being an agency where access is based on that presumption of access, for the state legislature, you go back to that sort of original 1974 version where there's a list of the types of records that you can access from the state legislature. And if you don't see it on that list, you're actually out. Every agency that's governed by FOIL is required by the Committee on Open Government's regulations, which have the force and effect of law, to appoint someone known as the Records Access Officer. Records Access Officer is like what I like to consider the point person for the Freedom of Information Law. They're the person to whom a FOIL request should always be directed, and the person who is responsible for coordinating the agency's response to the FOIL request. This certainly doesn't mean that they're the only person that's responsible for complying with the Freedom of Information Law. Everyone within a government agency has some level of responsibility with complying with the law. It's just that they are essentially the designated point person. So every agency must designate one or more persons as records access officer, either by name or by specific job title. Often it's job title in case there's turnover. Uh, Keep updating your policy. It just says job title. Like, for example, if you have a policy, maybe it says our town clerk serves as our access officer. Policy should include a business address and an email address. And that person, again, has the duty of coordinating an agency's response to public requests for access. Term record, again, very broad, and it means any information kept, held, filed, produced, or reproduced by, with, or for an agent, any physical form whatsoever. And then it gives a list of examples, but it's a non-exhaustive list of examples. So someone asks me, is this a record that is subject to FOIL? I say, can you read it? Can you see it? Is the information that is contained in a physical form? Then it's a record that's subject to rights of access under FOIL. First, doesn't necessarily mean it needs to be produced in response to a FOIL request, but it is a record subject to FOIL. For those of you that may work in a government setting, you might notice that how the Freedom of Information Law defines record is distinct from how the New York State Archives, the people who are in charge of record retention and disposition, defines records. The New York State Archives record retention people define records much more narrowly than the Freedom of Information Law does. For their perspective, a record is really the type of thing that a government agency is required either by law or regulation or by policy to maintain. Whereas under the Freedom of Information Law, if you put information in a physical form, regardless of whether you are required to create that information in a physical form or not, once you create it, it becomes a record subject. Under the law, an agency is not required to create a record. Doesn't mean that you're not required to, an agency is not required to make copies of records or to convert records into a preferred format if possible. Just means you're not required to manually create a new record. For example, you're not required to type up a list. If someone says, please make me a list of all people who work within a particular department. Well, no, you're not required to type up a list. You're not required to answer questions. You're, as an agency, required under the law to provide access to existing records. Almost every rule, there are exceptions. The exception here is that every agency is required to create and maintain a record of how every member of a public body that's housed within the agency votes on any matter. Every agency is required to maintain and make available a list of the name, public office address, so not home address, but public office address, title, and salary of all of its employees and officers. And the third exception is that every agency is required to maintain and make available a reasonably detailed subject matter list of records maintained by the agency. For local municipalities, it's very common for local municipalities to adopt the record retention and disposition schedule established by the New York State Archives. For local governments, it's called the LGS-1 as their subject matter list. And we've said that's perfectly acceptable. They line up nicely. To adopt the LGS-1 as a local government as your reasonably detailed subject matter list. Focus a little bit about that distinction between creation of a new record versus preparing a copy of an existing record. Sometimes I'll get a question, I'll say, well, so-and-so wants me to scan these records. Isn't that creating a new record? And the answer to that is no, it's just preparing a copy of an existing record. What the law states is that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have a copy made by engaging an outside professional service. So here we'll talk about, again, let's use the example of scanning. If someone have records that do not already exist in electronic form as an agency, the person who's making the request would prefer that the records be provided to them electronically as opposed to having paper copies. If you have the ability to scan just as easily as you would copy the records, that would be something you as an agency would be obligated to do. Scan the records, and if possible, you email the scanned records to the person who's making the request. And you provide them in, for example, a PDF format. Another element of this obligation is the law states when an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. Law states that any programming necessary to retrieve a record maintained in a computer storage system and transfer that record to the medium requested by a person or to allow the transferred record to be read or printed shall not be deemed to be the preparation or creation of a new record. So what does this mean in practice? Agency has a database, and the agency has the ability to query the database and produce a record that contains the information that's being sought. It's required to produce that record, even if it's not a record that the agency produces in its normal course of business. The agency has the ability to query the database, produce the record. It's required to do so. The applicant have an obligation to do in terms of the Freedom of Information Law. One is they have an obligation to put their request in writing if the agency asks them to do so. The agency can waive that obligation if they would like to. For example, if someone shows up at the town clerk's office and says, I'd like a copy of last week's meeting minutes, the town clerk is perfectly free to just hand over a copy without requiring the person to make a Freedom of Information Law request. Sorry, my voice is going on me a little bit, so I may stop and take little water breaks every once in a while. So that is one obligation if the agency requires it, that the person who is making the request must put the request in. Second obligation that the agency, or excuse me, that the applicant has is they have an obligation to reasonably describe the records they're seeking. So what does that mean? Well, the first part of it is sort of the common sense aspect. An agency receives a copy of the request. Do they even know what the person's asking for? The person using terminology that the agency is familiar with. Do they understand what the person's asking for? And if the answer to that question is no, then the person probably hasn't reasonably described the record sought. An appropriate response on the part of the agency would be to go back to the applicant and explain that it isn't clear to the agency what is being requested and to ask for clarification. The second part of this obligation to reasonably describe records is based on fairly old Court of Appeals case law. And the Court of Appeals is New York State's highest court. Court of Appeals held long ago that aspect of whether an applicant has reasonably described the records they are seeking will depend in large part on the agency's record-keeping system. is the agency able to locate the record with reasonable effort? If the answer to that question is no, very possible that a court would hold that the applicant hasn't reasonably described the record sought. So I'll give you an example here based on my own experience. Years ago, every government agency that's subject to FOIL is required by law to provide the Committee on Open Government with a copy of all appeals, FOIL appeals that they receive, and the response to that FOIL appeal. So they send us a copy of those documents. Years ago, what would happen is we would receive them, we would review them. If something raised a red flag or something, we might contact the agency. But in short, we would generally, after taking a look at them and reviewing them, they would get filed in a filing cabinet, as you might see on the screen, by date received. We didn't log them. We didn't have any sort of database of the appeals. They would simply get placed in a filing cabinet based on the date we received the appeal and the appeal determination. So if someone had come to us and said, please provide our office with, I'm making a Freedom of Information Law request for copies of all appeal determinations issued by the New York State Department of Health over the past 3 years. We would have had a very difficult time complying with that request. And based on the existing case law, we likely wouldn't have been required to engage in that search because we didn't file our appeals were not filed in a manner that would allow us to locate appeals issued by a certain agency. If someone came to us and said, please provide us with copies of all appeal determinations issued on March 14th, 1997, if we still maintained those records at the time, that's something we would have been able to do. But we didn't have a filing system that would allow us to locate appeals by agency. Within the past several years, we started logging those appeals. As they came in, we would just have a fairly simple Excel spreadsheet that reflects the name of the person who appealed the determination, the name of the agency that issued the FOIL denial of access, the date we received, some very basic, simple information. But it would have allowed us, if someone made that same request for all appeal determinations issued, for example, by the Department of Health, we would have known where to look because now we had a database showing when we received those. Time limits. So the Freedom of Information Law contains several time limits that an agency is required to comply with. The first time limit that comes into play is when an agency receives a FOIL request. Within the first 5 business days, they're required to do something. That first 5 business days, they can either provide access to the record that's being requested, they can deny access to the record that's being requested, they can state that they don't possess the record that's being requested, or the fourth option, which becomes more common, dealing either with larger agencies or when you're dealing with a FOIL request that is more voluminous or complicated. That fourth option is to acknowledge receipt of the request, give an approximate date by which the agency plans to respond. The law then goes on to state time limit. Once you've issued an acknowledgement, how long does an agency have to respond? Law states that in general, an agency will likely give an acknowledgement that states we need an additional 20 business days to respond to a request. However, if an agency states they need an additional 20 business days to respond to a request, that's almost always going to be deemed reasonable by the courts. There might be very limited circumstances where a court might say that's silly. You didn't need an additional 20 business days to respond to such a simple request. But in general, it's going to be deemed reasonable based on the language of the statute. But then the law states if an agency needs more than 20 business days to respond to a Freedom of Information Law request, they have an obligation to either at the time of the acknowledgement or at some time prior to the initial 20 business days, send another letter to the applicant, send a notice to the applicant, providing a date certain by which it plans to respond that is reasonable under the circumstances. In addition, the agency has an obligation to provide a reason why they are not able to respond within 20 business days. Again, it could be the volume of the request that they receive generally. It could be the complexity or volume of this particular request. We have in our regulations, there is a non-exhaustive list of what the Committee on Open Government, when promulgating its regulations, considered reasonable reasons why an agency made mistakes. So that letter has to give a date certain by which it plans to respond and a reason why it needs more than 20 business days. For years and years, the Committee on Open Government has advised that we do not believe that the law allows for repeated extensions. For example, we've always offered the opinion that agencies should not be sending out extension notices month after month after month. Courts don't always necessarily agree with the Committee on Open Government because from the court's perspective, the language of the statute is not as clear as we would like it to be. Some agencies have taken the position that those repeated extensions are not prohibited. From our perspective, unfortunately, the courts have generally sided with the agencies on that issue. But what the courts are going to look at is whether the extensions are reasonable under the circumstances. So that's something to keep in as a government agency. Is the amount of time that they're taking in order to respond to a FOIL request reasonable given the circumstances? If a denial of access is issued by an agency, an applicant has 30 calendar days to appeal the denial. Once the agency receives an administrative appeal of a denial, they have 10 business days to respond to. At some point in the past, maybe like 20 years, the Freedom of Information Law was amended to state that if an agency is able, it must accept requests by email. My thought is that every agency should be able to accept requests by email at this point. An agency cannot require that a requester use its own form. Require that the request be made in writing. But even if an agency has a form available for an applicant to use, which is fine, nothing wrong with making a form available for an applicant to use, the agency cannot require that the applicant actually use that form. If the applicant puts the request in writing, they've done their job. They've done what they're required to do. Unless there are personal privacy concerns, an applicant for record should be permitted to remain anonymous. So for example, if someone submits a Freedom of Information Law request for a copy of a record that was clearly public, let's say meeting minutes, a type of record that would be available to anyone that asks for it, and they send an email using a pseudonym, for example, such as, let's say they send it in as janedoe@gmail.com. They make the FOIL request for a copy, an electronic copy of last month's meeting minutes. The agency should simply turn around, provide the electronic copy. They should not be requiring the person identify themselves or provide any additional details about who they are. If it's a public record, the identity of the applicant is irrelevant. On the other hand, if someone is asking for records where disclosure might constitute an unwarranted invasion of personal privacy, unless the person who's making the request is the subject of the records, that's a different case. In that case, the agency would be free to ensure that the person who's making the request is the subject of the record. Appeals. There are two situations that give rise to the right to the applicant to file an administrative appeal. One is, this is not statutory language, it's just sort of shorthand language that I use, is express or an affirmative denial of access. And that's when a record is possessed by an agency, but they have issued a determination withholding that record in whole or in part. That's one scenario that gives rise to the right to file an administrative appeal. The second situation is what we refer to as a constructive denial of access. And that's when an agency fails to respond to a request for records within the time limit set forth in the statute. And this could be a number of things. This could be that someone makes a FOIL request and the FOIL request is never even acknowledged within 5 business days. It could be that it was acknowledged and the agency said they would get back to them within 20 business days, but failed to do so. It could be that the agency provided a date certain by which they plan to respond by which they plan to respond to the request, but again, failed to do so. Another option could be that an agency provides a date certain by which they plan to respond that the agency believes is reasonable under the circumstances, but the applicant disagrees. If the applicant disagrees that the date by which the agency plans to respond is not reasonable under the circumstances of the request, that is a situation that gives the applicant the right to file an administrative appeal. We do have model language for these types of appeals on our website. So if in this case you're an applicant seeking to file an appeal, we have model language for both express denials of access and constructive denials of access. So as you'll see, this is a lot of information smushed together on the screen. We're not going to talk about every single one of these. There's actually 2 of these screens that contain, but what I'll point out is that the information on the screen, which again is available on our website if you're looking for it, are all the statutory reasons why an agency deny access to a record or a portion of a record. We're going to go over some of the more common grounds for those denials today. The first permissible ground for denial, and this is the only time where an agency is required to withhold a record, is when a particular record is exempt from FOIL disclosure by state or federal statute. If a state or federal statute makes a record confidential, then the agency would be prohibited from disclosing the record. It's not FOIL that prohibits disclosure, it's the separate statute. If there is a separate state or federal statute that governs access to a particular type of record, the agency should always comply with that separate state or federal statute instead of the Freedom of Information Law. So a couple of examples here are attorney-client communications. Those attorney-client communications are, the access to those records is governed by the civil practice law and rules. Access to student education records, whether it's at elementary, high school, community colleges, SUNY colleges, CUNY colleges, all of those public institutions where that are governed by the Freedom of Information Law. Access to student records is not governed by the Freedom of Information Law and governed by the Family Educational Rights and Privacy Act, otherwise known as FERPA. Mental health records. For many years, I was the records access officer for the New York State Office of Mental Health, and sometimes we would get freedom of information law requests for an individual's mental health records, psychiatric records for one of the facilities that the Office of Mental Health operated. Those access to those records is not governed by FOIL, governed by New York State mental hygiene law, also by the federal HIPAA privacy regulations. Some perhaps lesser known statutes that govern access to records is New York State county law governs access to autopsy records, records created by a New York State coroner or medical examiner. So, autopsy records, access to those records is governed by New York State county law. Access to county-operated E911 records, including recordings and transcripts, is also governed by New York State county law, not by the Freedom of Information law. Another example is public officers law makes it prohibits an agency disclosing an individual's social security number. So as a government agency, whenever you're releasing a document, you want to make sure that if the document contains a social security number, that you're always redacting that social security number. Another example of permissible. So again, I think I mentioned a few minutes ago that there's only one situation where an agency is prohibited from disclosing records. That's when the separate state or federal statute states that they are prohibited from disclosing the record. All of the rest of the grounds for denial that are established under the Freedom of Information law are permissive. What I mean by that is an agency can choose to withhold those records, but is not required to disclose or withhold those records. So one of those permissive grounds for denial is when disclosure would constitute an unwarranted invasion of personal privacy. So examples here is employment applications of individuals that were not hired to fill a government job. Say you had an opening in a government agency, 10 people applied for the position, only one person was hired, and someone made a Freedom of Information law request for all the applications or resumes of the individuals that were not hired to fill the position. In general, those resumes or applications can either be withheld in their entirety or redacted in a sufficient manner to protect the identity of the individual who applied. And of course, and I'm sure everyone could understand that there are good reasons for this. Someone's applying for a new job. They might not want their current employer to know that they're job hunting. So you want to protect the privacy of the people that applied for the position. Home telephone numbers and personal cell phone numbers that might be contained on a record, whether it's the home telephone number or personal cell phone number of a general member of the public, or whether it's the telephone number of a government employee. If it's a home telephone number or personal cell phone number, that information could be withheld as an unwarranted invasion of personal privacy. Any medical information contained about a member of the public or a government employee, perhaps if you're talking about a government employee and they needed to take a medical leave for some reason, and that information about why they needed the medical leave is contained in their personnel file. If a FOIL request was made for that information, it could be withheld as an unwarranted invasion of personal privacy. Public employees' home addresses can be withheld on this ground. Lists of names and addresses of natural persons if that information is going to be used for solicitation or fundraising purposes. This is one of those very few situations where an agency is permitted to ask why the person who's making the request wants the records. Almost every other time, an agency really has no right to know why the person wants the information. So, really nothing wrong with the agency asking why the person wants the information. Sometimes it makes it helpful in order to focus on the best way to respond to a request. But 99% of the time, the agency is not entitled to know why the person is making the request. Here is the exemption, though, the exception. Uh, Say someone comes to the town clerk's office and makes a FOIL request for all the names and addresses of individuals who have been issued dog licenses in the past 5 years. The town clerk may ask that the person certify that they will not use that information for solicitation or fundraising purposes. It may turn out that the person perhaps has started a dog walking business and wants to send letters or emails to all the people who own dogs in the town. The law states that an agency can withhold this information if the person plans to use the information for solicitation or fundraising purposes. If you're not sure, as a government agency, as the records access officer, if you don't know why the person wants the information, you can ask that person and you can require, as a condition of disclosure, that they certify they will not use the solicitation or fundraising purposes, and that they will not share the information with anyone else who will use the information solicitation or fairly recent, within the past, I'd say 5 years, amendment to the Freedom of Information Law relates to mugshots. If a Freedom of Information Law request is made to a law enforcement agency for a copy of an individual's mugshot, that law enforcement agency is permitted to withhold a copy of the mugshot on the ground that disclosure would constitute an unwarranted invasion of personal privacy. A long and short of this is that public employees enjoy a lesser degree of privacy than others. There's a lot of information that you can find out about me as a public employee that you might not be able to find out about somebody who works in the private sector. Law enforcement. When you're dealing with law enforcement records, in order to determine whether there is a permissible ground for denying access under the law enforcement exception, it's a two-part test. And in order to withhold a record, you have to meet both parts of the test. The first is you need to determine whether the record itself was compiled for law enforcement purposes. And there was case law from 2017 where the courts have held that it doesn't really matter what the original purpose of the record was. It matters what the purpose of the record is at the time of the request. And to explain this, I'll sort of give you some background on the case law, is that at the time, the United States Department of Justice was investigating a former employee of the governor's office from the executive chamber. And they had required that the executive chamber turn over this individual's time and attendance sheets. Of course, time and attendance sheets are not generally considered to be law enforcement records or compiled for law enforcement purposes. Normal course of business, if someone makes a FOIL request for somebody's time and attendance records, that would not be considered to be a record that was compiled for law enforcement purposes. However, under these circumstances, at the time the FOIL request was made, those records had been compiled and turned over to the United States Department of Justice for a law enforcement purpose. So the executive chamber was able to take the position that the records being requested were compiled for law enforcement purposes. A second thing to consider here is that the exemption does not apply solely to records compiled for criminal law enforcement purposes and punishment of violations of criminal law. There's case law again from 2017 that held that records being requested from the New York State Department of Education, where the records were related to the New York State Department of Education's civil law enforcement oversight function, those were considered compiled for law enforcement purposes. So that's just the first part of the test, though. An agency can't just assert that the records were compiled for law enforcement purposes. They also have to express why disclosure would cause harm. And then the Freedom of Information Law establishes the harms visioned by the statute, by the legislature, where the agency can assert one of these harms. The first is that disclosure would interfere with a law enforcement investigation or judicial proceeding. A fairly recent amendment to Freedom of Information Law states that if the agency to which the FOIL request was made is not the agency that is actually conducting the law enforcement investigation, the agency who received the request has to go to the investigating agency and receive confirmation from the investigating agency that disclosure of the records would interfere with the ongoing investigation. In other words, let's use the example of a FOIL request is made to a local police department, but sort of the local police department's role in the investigation is complete because the records have now all been turned over to the district attorney's office, and the district attorney's office has sort of taken over the process. FOIL request is made to the local police department. They can't just guess that disclosure would interfere with an ongoing investigation. They need to confirm with the district attorney's office that disclosure would cause that harm if they want to assert that ground for denial. The second harm envisioned by the statute is that disclosure would deprive a person of a right to a fair trial or impartial adjudication. The third is that disclosure would identify a confidential source or disclose confidential information related to a criminal investigation. And here it specifies criminal investigation. So this Roman numeral 3 only applies to criminal investigation. Roman numeral 4 also only applies to criminal investigations. Roman numeral 4 says if disclosure would reveal non-routine criminal investigative techniques or procedures, those records or portions of records can be withheld. And here the point of this provision is you don't necessarily want to give potential lawbreakers the combination to the safe. You don't want to give them a mechanism for evading law enforcement detection. So if there's information contained in some sort of policy or manual that might allow a potential criminal to evade law enforcement detection or something else of that nature, that's the type of record or portion of record that could be withheld under the statute. Intra-agency and interagency material. This is another example of one of the permissible exceptions to rights of access, and it's intended to protect the deliberative process. So an agency can withhold any record that is maintained solely within a single agency or a record that is shared between one or more government agencies that are subject to FOIL. A lot of times a frequent example of this are email communications. It just have to be email communications. It could be draft documents or draft policies of some sort. But let's use the example as we kind of go through here of emails because it's a simple thing to follow. An interagency communication be, for example, between a town clerk and the town supervisor, or between the town supervisor and the town board. Those are all intra-agency materials, intra-agency communications. Interagency materials would be, for example, if someone at the New York State Department of Health emailed me at the New York State Department of State with a question asking for my opinion as to whether a particular record fit into one of the permissible FOIL exceptions. And then I might write back offering that person from the Department of Health my opinion. Those are interagency materials that if a FOIL request was either made to me at the Department of State or to the person at the Department of Health, they can be withheld because they reflect the deliberative process of the government agency. There are exceptions to the interagency and interagency material exception. If these communications or documents contain statistical or factual tabulations or data, that aspect of the record must be disclosed. If the communication or document contains instructions to staff that affect the public, those documents must be disclosed, or portions of the document must be disclosed. Final agency policies or determinations are required to be disclosed, and external audits, including audits conducted by the Office of the State Comptroller, need to be disclosed, unless another ground for denial can be asserted. Certification. There is a provision of the Freedom of Information Law in section 89.3a. 89.3a is a very bulky section of the Freedom of Information Law. It contains quite a bit of information. But buried inside is this provision related to an applicant's right to request a certification under certain circumstances. The language of the statute reads, upon payment of or offer to pay the fee prescribed, the entity, meaning the agency, shall provide a copy of the record and certify to the correctness of the copy if so requested, or as the case may be, shall certify that it does not have possession of such record, or that such record cannot be found after a diligent search. So part one of this has to do is someone makes a Freedom of Information Law request to an agency. Agency locates the record that's responsive and sends the person a copy. Maybe the person who receives the copy is suspicious as to whether someone made some changes to the document before providing it to them. What they have the right to do is request that the agency certify that the copy that was provided to the applicant is a correct copy of the original document maintained by the agency. This does not mean that the applicant has the right to request a certification that the contents of the record are accurate. It's just that they have the right to basically ask the agency to certify that the copy that they received looks exactly like the document maintained by the agency. The second part of this certification, this right to request a certification, is when an agency indicates that it does not maintain or cannot locate a record. The applicant has the right to request certification that the agency does not have possession of the record or the record cannot be found after a diligent search. If a certification is requested, an agency shall prepare this certification. It is obligated to do so. Sometimes we get asked, what's the time frame for providing a certification? The statute is silent in this regard, but my feeling is that if the diligent search has already been conducted by the agency, as it should have been, then there should be no delay whatsoever. Maybe a day or a couple of days should be all that an agency needs to turn around and provide that type of certification. If the person who receives the request for certification wants to do a thorough double check, that's more than reasonable. They go back to the staff and say, listen, we've received your request for a certification. Please do a double check that we don't have the record that's being requested. That's great. The people do a double check. And again, at that point, if the original search was done appropriately, then the certification can be provided to the applicant. I'll note here that a response by an agency indicating that it does not possess the record sought is not a denial of access that gives rise to the right to an administrative appeal. we often, from my perspective at the Committee on Open Government, we see quite frequently where an applicant wants, an agency will respond by saying, we don't have the records that you're asking for. And the applicant wants to appeal that. My explanation to them is an agency cannot provide what it does not have. So they're not denying access to a record that it possesses. It's simply telling you that it doesn't possess the records that you're seeking. So an appropriate response at this point is to request a certification. If you have some sort of, if as an applicant, have some sort of evidence that the agency should have the record that you're seeking, certainly point that out to the agency. It might perhaps help them form a more diligent search, but it is not a denial of access on the part of the agency that gives rise to the right to an administrative. So talking about appeals, when an applicant is denied access to a record, either affirmatively or constructively, they have the right to file an administrative appeal. And the applicant has 30 calendar days to file that appeal. By statute, the FOIL appeals officer is the head or governing body of an agency, or the person or persons designated by the head or governing body. Our regulations state that the FOIL appeals officer cannot be the same person as the records access officer. Within 10 business days, a FOIL appeals officer must either provide the records sought or fully explain the reason for further denial. Sometimes there's a combination of both those things. Multiple records were provided. It's possible that the FOIL appeals officer might uphold the appeal, provide access to more records than what was originally provided in the original determination, but might uphold the denial of access to the remaining. That's fine. The law does not contemplate a remand back to the records access officer. It is the responsibility of the appeals officer to review the records at the appeal level. This sometimes raises complications when the appeal is based on a constructive denial. Under those circumstances, it may make more sense for the records access officer to conduct that original review after the appeals officer has determined. Let me use an example here. For some reason, the original FOIL request slips through the cracks, an acknowledgement was never sent, and an appeal is filed. At that point, the appeals officer may acknowledge, yes, we messed up a little bit, we apologize. Here we are now, I am directing our records access officer to gather and review the responsive records, and we will get back to you within 20 business days. Does the law specifically authorize this? No. Do I think it's a reasonable way to handle the situation? Yes. Do I know what the courts would say under those circumstances? Unfortunately, I don't. But oftentimes, the courts are going to look at how reasonably an agency responded to a request. I think as long as the applicant is receiving the records that they're seeking in a reasonable time frame, that's what the courts are going to look to. And it may make perfect sense because it may very well be that by remanding back to a records access officer when the original denial was a constructive denial makes more sense because the records access officer may have to affirmatively deny access to records, and that's going to end up, that denial is going to end up back on the appeals officer's desk. So it's essentially giving the applicant a second bite at the apple as opposed to forcing them to go straight to an Article 78 proceeding. It just makes more sense sometimes for both the applicant and the agency. Just as a reminder to any government agencies that are on the program today and were not aware of this, as I mentioned earlier, an agency is required to send a copy of both the FOIL appeal and the appeal determination to our office. You're welcome to email it to us. It's coog@dos.ny.gov. It's at the end of this presentation on the PowerPoint, so you'll see it there. If you haven't been doing that, please start doing it. Hopefully everybody is doing it. So we need a copy of the appeal and the appeal determination. You're welcome to do it all at once if you would prefer, instead of sending the appeal first and the appeal determination later. It's not problematic from our perspective if you want to do it all at once. You don't, if you're the government agency, you are not required to send us copies of the responsive records that may be sent in the appeal determination. We just need the determination, not the records. Fees. And a lot of questions about what fees can be charged. There are two fee structures established by the Freedom of Information Law. One, and these fee structures should not be combined. It's either one or the other. First is when somebody wants paper copies of a record. This is happening less and less as we progress to, obviously more electronic age. The further we go along, the more electronic it becomes. The first fee structure is for photocopies up to 9 by 14 inches. So if someone would just simply like a photocopy of, for example, meeting minutes, the agency is permitted to charge 25 cents per photocopy for documents up to 9 by 14 inches. The agency is never permitted to charge for search or review time. You cannot charge for administrative costs. You cannot charge for the time it takes to locate the records. You cannot charge for the time it takes for an individual to review the records to determine rights of access. The second fee structure is for records either larger than 9 by 14 inches or for records in all other formats. So video, audio, data extraction, scanning. Those are all other formats. And that's when rule number 2 comes into play. The law sets forth what may be considered in determining the actual cost of reproduction. One of the elements that is allowed to be considered is the hourly salary of the lowest paid employee capable of preparing the copy, but only if it takes at least 2 hours to prepare that copy. My perspective, again, the simplest example that I can think of is scanning. Say, for example, you have records that don't already exist in electronic format, they only exist in paper form, and in order to provide them in an electronic format, the agency would need to scan the records. So if it only takes 15 minutes, 30 minutes to scan those records, no fee will be allowed to be charged by the agency. On the other hand, if it is you've got 10 file boxes worth of records that need to be scanned, perhaps even placed on an electronic storage device because it's such a large amount of records, it can't even be emailed, then what can be charged is the hourly salary of the lowest paid employee capable of performing that scanning, multiplied by the number of hours it took them to do the scanning. You can charge for the cost of an electronic storage device if you need to, and that's thumb drives, DVDs, CDs, whatever the case may be. If as an agency you do not have the technology to make a copy in-house, sometimes this relates to things like blueprints and maps or audio or video, things where the agency does not have the technology to make copies in-house and they need to send it out to the third-party vendor to make the copy. Whatever the third-party vendor charges the agency is the fee that the agency can then pass along to the applicant. Again, an agency cannot charge for search or review time. Cannot charge for the time it takes to locate the records or to review the records to determine rights of access. And no matter how many times I say this and how many trainings I do, I often get people, I hear stories about agencies attempting to charge the individual for the time it took them to gather and review records. That is not a reimbursable cost under the statute. The Freedom of Information Law requires if it's fee structure number two, meaning anything other than photocopies, the law actually requires that you notify the applicant in advance of the fee to make sure that they're willing to pay it before you incur the cost. So for example, if someone wants a copy of a map or a blueprint or something like that, don't just send it out to the third party vendor without making sure first that the person who made the request is willing to pay that fee. Um, Even though this rule only applies to number two, I think it's a good practice to do for all requests for records, particularly if it's going to be a significant fee. If someone makes a request for photocopies and it turns out you've got thousands of pages of documents that are responsive to the request, I think it's a really good idea to notify the person of the cost of the photocopies before actually incurring that cost on the part of the agency. Because the person might just be able to say, I just can't afford that. I can't pay that. Um, and you're, as an agency, you're always free to either get a deposit or request that the person pay the fee in advance prior to incurring the cost. There was a fairly recent amendment to the Freedom of Information Law, just signed this past winter, that states that in the case where an identical record has been prepared for a previous request within the past 6 months and an electronic copy is available, an agency shall not charge a fee. This is somewhat common sense because if you have an electronic copy of a record, there really would be no cost to making another copy. If you have it in electronic form, you would just, for example, just attach that electronic document to an email and send it out. I think this is meant to address situations where agencies are attempting to charge multiple individuals um, for the time it took to make the original electronic copy. But if the agency already has the electronic copy, the agency should not be attempting to charge a second fee for the time it took them to make the first electronic copy. And the 6 months is intentional because that's the record retention period for FOIL requests. So once an agency has responded to a Freedom of Information Law request, the New York State Archives record retention and disposition schedule requires that they maintain those records for 6 months from the time that the final determination is made. So it's either 6 months from the point that the initial determination is issued, or if there was an appeal and then an appeal determination, you need to maintain those records for 6 months from the final determination. So that's why they use 6 months. The second part of this amendment states that if more than one request is made for an identical record before the first request, I guess, has been fulfilled, any fees charged by the agency must be apportioned equally among the requesters. So say, for example, within a couple of days, an agency receives 3 requests for the same exact set of documents or the same data extraction, whatever the case may be. Whatever the fee is that you would have been permitted to charge the original requester should be split among the 3 applicants. That's what this new amendment is. Enforcement. Enforcement, the Committee on Open Government does not have enforcement authority. Unfortunately, we have to tell people this probably almost every day of our professional lives. Somebody from our office is always having to tell some unsatisfied individual that the Committee on Open Government does not have investigatory authority. We do not have enforcement authority. We have the ability to provide advice and guidance regarding the Freedom of Information Law and the Open Meetings Law. We do not have enforcement authority. enforcement of both the Freedom of Information Law and the Open Meetings Law is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. For purposes of FOIL, a successful petitioner who brings an Article 78 proceeding against a government agency can receive attorney's fees and other reasonable litigation costs. Those attorney's fees and reasonable litigation costs are mandatory on the part of the judge when the requester has substantially prevailed and the courts find that the agency had no reasonable basis for denying access. It is discretionary on the part of the judge when the requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time frame. So finally, I'll note questions. Anyone is welcome to contact the Committee on Open Government with questions about Freedom of Information Law, the Open Meetings Law. You can be a government employee, you can be a member of the public, you can be a media representative. It doesn't matter what your status is. Anyone is welcome to contact our office by phone or by email. Up on the screen, you see our office telephone number. We are a relatively small office, although we're like double the size of that we were a couple of years ago, which is quite nice. Up till 2021, we were a staff of 3. Now we're a staff of 5, which is very exciting. So we have 2 additional senior level attorneys that have joined our staff fall of 2021, which has been wonderful. So if you call our office, you're welcome to speak to any of the attorneys in the office. You can just say, could I speak to one of the attorneys in your office with a question? Or if you email coog@dos.ny.gov, the first attorney in our office that has an opportunity to get back to you will. So it just makes it a little bit faster. I mean, certainly if you've already have a pre-existing conversation going with one of the attorneys in their office, it's perfectly fine to keep up that conversation with that individual. But if for expedience sake, emailing the Coog address bound to get you an answer a little bit more quickly. I'll repeat what I said at the beginning of the program, is that this PowerPoint is available on our website under the section on our homepage that says, I would like to view training materials and recordings. There's copies of our PowerPoint. And within a week or so, there's going to be a recording of this particular program posted up on our website. We have a YouTube page that contains all the recordings of the programs that I've been doing over the past couple of years. We're looking to maybe want to share with someone else that wasn't able to log on today. A copy of this particular recording should be available. So at this point, I'm just going to open up the chat feature, stop sharing, start my video, go to, sorry, I'm just looking for my chat feature, chat. I'm used to being, a lot of times I'm in my office and I have all my nice multiple screens. I love having my multiple screens. Today, stuck in my guest bedroom. My significant other also couldn't go into work today because of the bad weather, so we had to kind of split up the space in our house. So I'm going to skim through our chat feature. Skimming through the parts about my faulty sound. Someone has asked the question, what about confidential investigation files held by third-party investigators, i.e. direct care providers? I'm not quite sure what's meant by this. If a government agency maintains a record, it needs to review the record, A, to determine whether there's any state or federal statute that prohibits disclosure of the record. And B, review, if there's no statute that governs disclosure of the record, you're going to look at the record to determine whether, for example, there's disclosure would constitute an unwarranted invasion of personal privacy, or any of the other grounds for denial that are included in the statute. The person who has asked this question would like to follow up with us directly with specific information um, about the type of record that they're asking for. But essentially, almost every record, it's going to come down to content. Sometimes we just get people asking us, well, what about this type of record? What about this type of record? And unless there's a statute that governs disclosure of a particular type of record, almost always it's going to come down to content. What does the record actually say? What's in the record? That's what's going to help you determine whether the record needs to be disclosed in whole or part. Someone has asked whether agencies are required to broadly interpret a request within reason. An applicant is seeking email communications with attachments from a contractor to an agency, but the officer designated a subordinate to receive email communications from the contractor. Is the agency required to alert the applicant to the fact and provide the communications from the contractor to the subordinate? Well, this is going to come down to reasonableness. If the subordinate is the one who has been designated to receive on behalf of the officer, I'm going to assume that the communication was actually intended for the officer and it probably fits within the request. I always encourage agencies not to sort of play games about and not try to use technicalities to get out of having to provide particular types of records. It's always best to simply interpret the request in a reasonable way. Think about what is the person looking for. If you responded by saying, no, there's no communications, is that going to raise red flags? Because how could there possibly be no communications? It just, that you would want to, in that particular situation, probably interpret the request a little bit more broadly. The applicant probably has no way of knowing that there's been a designation. If a person requests an electronic copy of a document, but the municipal agency must redact by making paper copies, may the agency charge for the cost of making such redactions? So here the question is, like, say, for example, you have paper copies of the records and the person has said, well, I want you to just scan those records to me. So I don't have to be charged for photocopies. If the only way for you to redact the record is to make a photocopy and then manually redact the record, for example, with a Sharpie, yes, you can charge for photocopies. If, on the other hand, if you have redaction software like Adobe Pro and scan a record and then redact it electronically using that software, then no, you wouldn't be able to charge for photocopies. You're never able to charge for the time it takes to make the redactions. You're only able to charge for the cost of making the copy. Someone's asking a question about the 2-hour rule. If the effort for I think I understand the question is, if it takes 5 hours to prepare a copy, for example, if it takes an agency 5 hours to scan records, you are allowed to charge for all 5 hours. You don't have to subtract that first 2 hours. In fact, once you hit that 2-hour mark, you can charge for 2 hours. If it takes your agency 2 hours and 1 minute to prepare the copies, to scan the copies, to extract the database, whatever the case may be, you can charge for that first 2 hours. If it takes 5 hours, you charge 5 hours. You don't have to subtract that first 2 hours. It's just the law says that if it takes less than 2 hours, you can't charge at all. Someone's asking about EIN or TIN numbers for vendors. Generally, that is not, because the person who's asked the question is comparing it to social security numbers. EIN and tax identification numbers are generally not confidential. There are very limited old circumstances where you had companies that were created quite a long time ago, where it was maybe an individual contractor that started their own business. And when the federal government wanted to assign them a taxpayer identification number or an employer identification number, they simply took their social security number and converted it, like sort of basically changed the spacing and turned it into their social security number into an employer identification number. But the federal government has not done that for a very long time. Those types of numbers are broadly available, for example, for not-for-profit entities. If you go to GuideStar and you can pull up a not-for-profit entity's tax filing documents, and you can get their EIN or TIN quite simply. So in general, no, there's no confidentiality associated with EINs or TIN. Someone asks, you mentioned that the list of names and addresses of individuals for solicitation purposes considered an invasion of privacy. What about addresses and names of businesses? No, the answer is no. Business entities do not have personal privacy. Only natural individuals have an expectation of personal privacy. So if someone makes a Freedom of Information Law request for lists of vendors and those addresses, those cannot be withheld on the grounds that disclosure will constitute unwarranted invasion of personal privacy, even if it's an individual acting in their business capacity. You've got a sole proprietor and they are a vendor working for a municipality. If they're working in their business capacity, information about them cannot be withheld on personal privacy grounds. Someone says if inter communications via email subject to redaction is a website linked to a government page considered factual information which should not be redacted. Yes. I guess the answer to that is yes. If it's objective information, it's not information that reflects opinions, impressions, recommendations. If it's objective information, that's what the courts are going to consider factual tabulations or data. Would records shared with a federal agency lose its interagency exemption under FOIL? If a communication is sent to a federal government agency, that is not an interagency communication. Once a document is shared with a federal agency, in general, it is no longer an intra-agency or interagency communication. If an agency asks a requester to better describe the records sought and the requester does so, is there a timeline for the agency to reply? The law doesn't specifically address this. It's, my feeling is once the agency receives a FOIL request, that it can then start processing, that's really when the time limit starts ticking. So if an agency receives a FOIL request and right away comes back and says, I don't understand your FOIL request, I'm going to need you to provide clarification. Once that clarification is provided, that's, I think, when the clock starts ticking. What becomes problematic sometimes is that when an agency takes way too long to advise the applicant that they don't understand the request or that they need additional information. Certainly that should be happening right off the bat. That should be happening right within the first 5 business days. An agency should not be, waiting a month or 2 months to tell an applicant that they have not reasonably described the records sought. That should be happening right away. But in general, my feeling is that once a request for records that is reasonably described has been received by the agency, that is when the clock starts ticking. Someone asked a good question about what form does the certification take? In other words, does it need to be a signed and notarized document? There are, in our opinion, the answer to that is no. There are court decisions out there that says that reaffirm that the Freedom of Information Law does not dictate the form in which a certification uh, must take. If an agency, for example, someone requests a certification by email and the agency responds by certifying, and I'll use an example, I, Kristen O'Neill, certify that the Committee on Open Government does not possess copies of, and then usually I like to include a description of the records that were requested. I put my signature block at the end of the email. In our opinion, that's sufficient, and I think the courts would agree with that. It doesn't have to be, there's no obligation for it to be notarized. As far as I'm aware, there's no court holdings even requiring that it be like a signed piece of paper, just that sort of takes the language from the statute and and offers that to the applicant. I certify that the agency does not possess or that the agency cannot locate after a diligent search. If an agency knows the partners in an LLC that has an application in front of the municipal board, can the names of the partners be foiled? I think what it comes down to is, as I said at the beginning of the program, all records maintained by a government agency are subject to the Freedom of Information Law. Once the agency locates the records, they either have to disclose them or they need to assert one of the permissible grounds for denial. They're never going to be obligated to answer questions or provide information that does not exist in record form. They just need to provide access to records, existing records, consistent with the requirements of the law. Getting pop-ups, I apologize. This is again the problem with having my just one little screen. If an agency doesn't have a complete collection of documents requested within the 5-day clock has expired, is the agency required to submit a partial collection? I think what I, and the person who writes this, if they want to clarify with me later, that's fine. There's this Freedom of Information Law doesn't really address an obligation of an agency to provide records on a rolling basis. Do I think it's a good idea? Sure, I always like to do it as records access officers. To be honest, as the sooner I can get things off my desk, the better it is for me as the records access officer. So I like providing records on a rolling basis if I have the ability to do so, but the Freedom of Information Law doesn't affirmatively require it. So if an agency would prefer to wait until they have all of the records that are responsive to a request gathered and then review them all at once, I think the law allows for that. I don't think they're required to provide them on a rolling basis. This is a follow-up on an earlier question about federal agencies. For communications with a federal agency and/slash city state officials, what exemption applies to withhold records for that under FOIL? There is no blanket exemption for records for communications with a federal agency. It would depend on content. If there's content of the record that fits within one of the other statutory exemptions, that's great, but there is no blanket exemption for record for communications with a federal agency. They don't fall within the interagency intermaterial exemption. They don't fall within section 87(2)(g). think I've come to the end of my questions in the chat feature. I just want to double check because sometimes people put things in Q&A and I forget to look. Hardly ever use Q&A, so I just want to just a sec. Well, I think we've come to the end of our questions. I appreciate everyone joining. Oh, we got one more. Our appointment calendars for members of an agency who goes on a taxpayer conference foilable. All records of a government agency are subject to FOIL. In fact, not too long ago, someone made a Freedom of Information Law request for my work calendar for the past 2 years. I converted them to PDF, handed it over to our records access officer. She reviewed them. She redacted anything that might be personal on my part, because once in a while I'll put something, for example, on my work calendar saying, take my daughter to the doctor's office or something like that. But an appointment calendar is a record subject to the Freedom of Information Law. Whether any of the calendar can be redacted is going to depend on content. There, that was the end of our program. It works out perfectly. We're now at 11:30, which is the hour and a half we talked about. Again, the recording will get posted within a week or so. The materials are posted right now, the PowerPoint. I appreciate everyone joining me today. For those of you that aren't aware, I'm going to be doing the Meetings Law program this afternoon. Still available, I think, for registration if people would like to join me. You all have a great day and the great eastern part of the state. Stay warm and safe. Thank you. Bye-bye.